On the Commonwealth versus Ana Walshe. Can I have counsel identify themselves, starting with the comment?
Good afternoon, Your Honor. Greg Connor for the Commonwealth.
Good afternoon, Mr. Connor.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. Good afternoon, everyone. Kelli, Porges on behalf of Mr. Walsh.
Good afternoon, Ms. Porges.
Good afternoon, Your Honor. Larry Tipton for Mr. Walsh.
Good afternoon, Mr. Tipton. Good afternoon, Mr. Walsh.
Good afternoon.
Mr. Walsh, you can have a seat, sir.
Thank you.
Mr. Tipton, I've read your motion, an affidavit, a memorandum. I've read the Commonwealth's response. Have you had a chance to look at any of the materials that it seems like maybe the Commonwealth gave you in the last week from when the motion was filed, or?
No.
Okay.
Because, frankly, we just got it.
All right, so what are we doing today?
Well, I don't want to speak for the Commonwealth, and I want to make sure that Mr. Walsh understands, because I just told him something different in lockup.
Okay.
I think, based on the representations of the Commonwealth, both in its communications yesterday and then today, there's a lot of discovery forthcoming, some of which addresses some of our requests, some of which we don't. So I think it's a waste of our time to argue this extensive motion and memorandum of law. And I was going to explain why we filed such a detailed memorandum of law, but I don't think I need to waste the court's time with that. So I think what we're suggesting is, at least what we're suggesting, is that we come back on December 2nd, having had a chance to review what is coming, and then
Narrow the motion as to what you might still need. All right, sure, that's fine. If you determine that some of what you're requesting is Rule 17, do you anticipate being able to file them that day or not? I'm not telling you have to. I'm just...
Well, I can tell the court that we're certainly looking at our request to see if they require Rule 17. And I'll just very briefly say that in our memorandum, when we address internal affairs, we are suggesting that right now, under the present facts and circumstances that we argue in the memorandum, that a Rule 17, even for internal affairs, isn't necessary given where we are today. And the court may certainly disagree, and we said in our memorandum, if the court orders us to follow Wayness, we will. But if we know that a Rule 17 will be required, I would anticipate we bring it with us.
And it's in not necessarily regarding the internal affairs,
Right.
but other things you were looking for. I thought were probably a little bit more obvious. Rule 17.
Okay.
So that's what I mean, not those. I understand litigating whether the IAD information is Rule 17 or Rule 14. I can see that maybe we will have to have that discussion, but the others that I think maybe after you look at what you have, you might think is Rule 17.
Right.
So on those, do you anticipate you might be able to file them by then, or it's too early to tell?
I think it's too early to tell.
Okay. How about if you can, you will?
That's absolutely right.
Okay. Does that make sense, Mr. Connor?
Perfect sense, Your Honor.
12-2 works for me. Jimmy, does it work for you?
It does. It does.
Okay. Do you want Mr. Walsh brought in that day?
I think we should issue a Hague, and then Mr. Walsh and all of us will talk and see if he needs to be brought in. But
Okay.
if we're going to have a hearing, yes, I do.
Sure. So we'll bring you back, Mr. Walsh. But if you don't want to come, let us know. And I think that.
And just finally, and I don't want to interrupt another Commonwealth, but the Commonwealth has filed a motion for protective order
Yes.
for some of the stuff. Right now, the status of that, we don't object to the protective order. What our understanding is that we can share the information with Mr. Walsh, but we're not going to give him hard copies of anything just yet. And we don't object to the redactions that appear today. We just want to review what we have, and then we'll come back. That's our understanding of the protective order.
That's our joint understanding, Your Honor.
Okay. That's what I would order anyway at this point. So, all right. So I'll allow them to call a motion for protective order. All right. We'll see you December 1st.
December 2nd.
December 2nd.
December 1st.
All right.
Sounds good.
All right. Thank you all.
Thank you, Your Honor. Thank you.
Thank you.
Court, all rise. Court is now back in session. You may be seated.
This is 23 CR 911, the Commonwealth versus Ana Walshe. Counsel identify themselves, starting with the Commonwealth.
Good afternoon, Your Honor. Greg Connor for the Commonwealth.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Your Honor. Good afternoon, everyone. Kelli, Porges on behalf of Mr. Walsh.
Good afternoon to Flores and good afternoon to the defendant. Happy to see everyone, and I'm going to go through what I have on my agenda, and then I'll address with you whatever, if I can, address with you whatever questions you have. On my agenda today is to talk about the pending discovery disputes and see if we can make some forward progress on that today, either today in the hearing or if not, ruling in the near future. I want to discuss the scheduling order and where I see this case going in terms of progressing forward and discuss the joint motion that you submitted last week. And the preview for that. I guess I don't see this case going into 2026 for a trial. I think it should be tried in 2025. I'm certainly going to do my part to make sure that it keeps on track to get us there. And that's due to, in large part, the age of the case and its respective complexity or not, and the range of cases like it. So I think that it's reasonable to assume that a case such as this one will be tried within 2 years. Indictment on the present schedule we're looking there that you suggested, I think it's coming closer to the 3-year mark, and I think that's a little unnecessary. And nothing gets better with time. People's memories don't get any better, and the case isn't going to get any stronger. People's memories fade over time, and so I've been interested in making sure the case gets tried as efficiently as is possible, respecting the numerous issues that have to be addressed. So we'll talk about that, and then I think attenuate to the motions that have been filed, we're going to need another date, or perhaps need another date on Rule 17 motions, which I appreciate the defense filed to come up, I assume, based on your earlier pleadings, and third parties may be filing objections to those, so we'll get that on the calendar. With regard to the calendar, I'm happy to come down here today. As you know, I have been specially assigned. I want you to know when we're picking dates for future things that it's highly likely you're going to be traveling. I'll try to travel here when I can, because I know that this is where it is, but you should also build in the expectation that you may be traveling, and the travel in the next 3 months is going to be to Middlesex County, because that's where I'm going to be assigned for the first quarter, deliberately not far from. Let me say that just so that you sort of have an idea of what my knowledge base is, and I've gone back and tried to listen to a number of the hearings on the case, most notably, I guess most importantly, your last hearing before Judge Cannone, when this issue with regard to, I think as Attorney Tipton said, it was an exhaustive or extensive discovery request came up, and you all thought that you could make some headway, and you did make some headway, although there's some disputes that still linger. At that time, so I listened to that last hearing. I also went back and listened to a hearing on June 24th, in which the parties informed the court that the trial date was too tentative at that point, at least 6 months ago. I have before me now what are the first round of discovery disputes. Those were docketed just for the record, and as paper number 18, the defendant's motion for discovery of documents related to the district attorney and law enforcement. That then gets updated by your second motion, which I got filed on Friday. That's paper number 32. I've gone through those. I've gone through the Commonwealth's oppositions to those. And then also I received on Friday paper number 31, which is, I'll call it the federal investigation motion, and the Commonwealth's opposition to that, which I just briefly, I got it just as I was coming down the stairways, and I've read it, but I haven't given it much thought. The first thing I wrote before I got your position was do a two-way request. And so I see that at the end of that, we'll get to that in a minute. So I've read all the pleadings. I have looked at some of the law that I want to look at. There's one thing that I didn't get a chance to look at this morning, but I'll hear from you. And perhaps the best way to do it is to just go item by item and identify, I think it pretty clearly now identifies where there's a variance. If you wish to be heard on any of the orally, I'll certainly give you the opportunity to do that now. If you want to rest on the paper, so that's fine too. I may have questions as we go through. But why don't we all just turn to paper number 32 and go through those now.
Would you like to start?
Sure.
By and large, Judge, what we're asking, just turning to page 2, paragraph 1, subparagraph A,
Yes.
we continue to ask for disclosure. I understand the reality of this is that they've engaged an attorney who I am familiar with professionally. And like I say in our motion, we don't object to Attorney Sack being assigned to review. So we have no objection to him. And I'm not familiar with Jim Carney, but I have no objection to Jim Carney. It's just that we believe, based on the existing case law and the citations that I've provided in the memorandum, that defense counsel is in the best position to assess the exculpatory nature and the utility of this information, whether it impacts bias, credibility, or the Bowden defense of the conduct of the investigation. And for those reasons, and I'll leave it at that, we ask this material that the Commonwealth declines to turn over be turned over. Other than that, that's all I'd have to say on that particular issue.
So, Your Honor, I can tell you that not only did we retain Attorney Sack, and he's received the download of the phone, I am also going through the phone through all of the emails and all the text messages and anything that could be a statement to try and find Brady. But I'm also focusing in on Rule 14 statements, and I feel it's my duty under Graham and McFarland to go through this myself and find anything that could be potential bias, but also statements, and I'm doing that. I've focused in on all
I'm
of
happy
it.
to hear that because you'll find that I try to be as transparent as I can to both sides. And when I read this, I don't know Attorney Sachs and I don't know the computer person either, but this is interesting. Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it, but I've seen special ADAs, special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And I honestly I don't think they can do that. They can delegate that responsibility to an attorney. It sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check.
Yes, Your Honor.
Something.
That's the purpose of Attorney Sack. It's not to outsource it, but to double check with the Commonwealth and stuff.
Okay.
And he's doing it independently.
All right. That's always good to have another set of eyes. All right. Anything else that you want to talk about with regard to this?
Not beyond what's in the papers, Your Honor.
By the way, what I'm probably going to do is following this hearing is I'm going to give you an omnibus order on discovery. I'm going to follow your sort of how you set up the issues because it makes sense. And so I'll just go 1, A, B, C. It makes sense. And I'll probably be doing that more quicker than I was going to be my trial attempt on this. So I'll have an opportunity to look at this while it's fresh in my mind. I'll get something out to you. I will tell you that preliminary view on this is that it's the Commonwealth's obligation. And that has happened, or that I've read so far, turns that on its head. And the idea here that I understand that the defense is a very unique perspective on every piece of evidence. That's just a different view than a prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information that I know. But that's just my preliminary view, and I want to give some more thought to the arguments that have been made. All right?
May I proceed? Are we done?
Yes, please.
With regards to paragraph number 2, the request regarding the 37 to 4 pages, I will defer to Attorney Kelli Porges, who at the time we finish this motion, she'll be arguing the motion that addresses that request, I think.
Okay. That's the motion paper number 31.
Yes.
I will defer on that one.
We don't need to touch upon paragraph 3. We're waiting for production of those letters. Paragraph 4, we don't need to address. We're withdrawing that at this time.
Right.
Regarding paragraph 6 is really subsumed in Rule 17. We'll deal with it.
5 is not an issue either, right?
5 is not an issue. And once again, paragraph 7, that's assumed in the Rule 17 request, I do believe. Number 8, we all agree, at least the Commonwealth, and we agree that that's captured in paragraph number 5, the request 5. And moving ahead through now to request number 14, what we're trying to do is say that the Commonwealth needs to produce this unless it can make a sufficient showing of what it characterizes as the basis of its argument, that what we're asking for implicates the work product. And where I would agree that if the work product rule under 14A5 is in fact implicated, I understand that they would have grounds to say they can't disclose it. But I find it hard to believe that what we're asking for, that the entire universe is captured as work product. And so for those reasons, we ask that that request be allowed in so much as what we've asked for.
Why isn't a good initial step to just say, have them, we commonly see this in civil litigation, but go through, and it's perfectly appropriate for criminal litigation as well, to go through and say, this is the basis for the work, this is, the privilege law. And at least give the defense then the universe of what the responsive documents are, and if it is.
Your Honor, there are some items that would be published that we would have the burden to show. That being said, the Commonwealth is producing any and all notes written by any of the officers, investigators in this case.
I saw that.
In reaching out to, we've also produced any and all notes and reports from the crime lab. We're reaching out to OCME to see if they have any additional notes. So the only notes that I can think of that aren't being produced would be mine.
Okay.
And my notes would be on scheduling, strategy, theories, thoughts on the case. And so at this point in time, those would be working.
All right. Do you have any objection to putting those in a law?
I would, yes, Your Honor. I
Why?
would. Well, because
I'm asking you from the date, if you have in your notes. If it's an internal note to yourself, that's it. Internal note, ABA Connor, date. I'm not asking you what's in there. You can say,
it's just
you can
not
say as blandly as trial strategy. if that's what it is.
Well, my notes might not reflect dates so much as where I am sitting at my desk writing down theories. So the best I could do would be to say,
I'm not asking for that, Attorney Tipton, right? Come on.
so I will go through my notes and see if there is anything that would be discoverable under Rule 14. But as of right now, I can't think of anything, but I will double check. And if it gets to the point that I have to create a log, I will. But I will see if there's anything that contains a statement under 14.
If there's any, if this is a series of notes, it seems like an exercise in futility for you to have them do the log. I'm just saying if there's something more complicated or complex than that, because I'm clearly not giving, you don't want them, you're not going to get them. So if it's something more than your notes, something going back and forth that reveals strategy, perhaps with you and the investigators, I'm not going to have you produce that either. But he wants a record, and he's having Attorney Tipton's, credibly saying that he doesn't think that that's the whole universe of what would be out there. It may be.
And so, Your Honor, we're talking about communications separate from notes. Like I said, I'm going through the emails and text messages that are in the phone. And if there is anything in there that's under Rule 14, as far as a statement of a witness, that's going to be turned over. And, I intend to be as liberal as possible, understanding what could be 14. But if there is something in there that is trial strategy, and I think that it could get to that point, we're talking about statements in the phone, then I would create a law.
Okay.
I would create a law. Because that it seems like the appropriate way. If we're talking about the phone itself, but when I say the phone, I'm talking about Michael Proctor's work phone.
Right.
I'm not looking to go through every person's phone. I have no knowledge of what is in every other person's phone. But Mr. Proctor's phone is distinctly in the custody and control right now, or the download of it of the district attorney's office.
Okay. All right. So with regard to that, let me finish by saying, any notes, I know you'll see this in the omnibus order, any notes that are internal notes to prosecutor, I don't need to see that privilege log. If you want to revisit that, Attorney Tipton, let me know. If there's something that comes up in the course of your review of the phone that is of the sort, I know it varies a little bit off of what we're talking about right now, particular requests, start making a privilege log.
Yes, sir.
And honestly share it as it's being updated.
Yes, Your Honor.
Okay? All right.
Focusing our attention on both paragraphs 15 and 16, I think I can just argue these both together.
Sure.
And the gist of this is our request is because the Commonwealth has said they are not in possession of anything and any knowledge at this point, my subparagraph F, really what we're asking for then is to make sure that the Commonwealth, in an affirmative fashion, requests cellular records and text records of the Cohasset police that would impact and bear upon bias, credibility, or the investigation. And I say that because without an inquiry by the Commonwealth of its agents, that being the Cohasset police, we really have no way of seeking this type of information. But more important than that, that given what we now know about what has and may have occurred within the ranks of the Mass State Police assigned to the District Attorney's Office, and I'll just add, without trying to sound hyperbolic about it, but in the Boston Globe today, there was yet another report talking about the failings, if you will, of the Mass State Police in the way it disciplines its officers and the way that certain officers, at least one, was promoted even after significant complaints were made. I think to fulfill McFarland and Graham and the requirement of Mass Rule Criminal Procedure 14A3, that the Commonwealth should be required to inquire specifically whether the Cohasset police have checked, and I'm not talking about all the police officers, I'm talking about the Cohasset police, and there's 3 primary officers involved in the investigation of Mr. Walsh, to see if they have anything that comports with, and who knows if they would disclose it, but I would hope they would, comports with text messages and emails and cellular phone records that indicate a bias, a prejudice, and a lack of professional integrity when it comes to investigating Mr. Walsh. And I will say that it was the Cohasset police, and I'm not casting aspersions on the Cohasset police. I'm just saying that if it's out there, the only way to really get to the bottom of it is if the Commonwealth fulfills its duty of inquiry and then returns back and tells us. I leave it at that.
Who are the 3 Cohasset police officers you speak of?
Schmidt, Lopes, and the third name is eluding me right now.
Any Connor, when you want
Well,
to have the third name? Or
I would suggest that Harrison Schmidt and Anthony Lopes were the lead investigators for the Cohasset Police Department. Several Cohasset police officers did aid and help. So if you were to say that there was like a B team that was helping with the initial investigation, that would be more than just those two officers. But Lieutenant Lopes went to Washington, D.C. and did some investigation, and Sergeant Schmidt has been the case officer for the Cohasset Police Department. So, Your Honor, as far as a duty to inquire, I am happy to inquire of the Cohasset Police and the state police investigators to see if there are any statements in text messages or emails that fall under 14 or are exculpatory, for instance, under Brady, McFarland, and Grant. I'm prepared to do that. That being said, cellular records is a bit more of a problem because I don't think a cellular record, whether it be a call detail record, would necessarily show anything. It would show maybe a call takes place, but I can't tell you that that call is about the Walsh matter.
And well, and that's what I wrote my notes next to see is how would a telephone record tell you whether it related to this case or not?
Let me just apologize for being unclear about that. I should have been much more specific. I really wasn't looking for phone logs or anything. I was looking for something that was contained on their cellular phones, such as whether it be emails or text messages, or the written word that would be indicative of bias, and credibility issues. I am not interested in, at this point, of looking at phone logs, and I apologize for not being more.
So with that, I would inquire of the officers.
All right, so we have,
Yes, Your Honor.
okay,
Moving along, number 17, we withdraw
yes.
as we continue. Number 18, and once again, if I could just point the court's attention and the Commonwealth to subparagraph G. That is that's one of the most inartful sentences I've ever
I
drafted.
don't want to hear what I wrote next to that.
Probably you said something a lot more stern than inartful, but it's what it was meaning, what it was meant to convey. Was it? I'm sure the government is aware of the fact if something in their possession was destroyed or altered, and they would tell us that. I've been working with this DA's office for 2 decades.
Right.
So when I read that this morning in preparing, I cringed because it suggests that they're unaware of their own mistakes.
That's how I read it.
What I was trying to say was when they respond that they're unaware of anything being destroyed or altered, at least by their office, I take that at their word and I understand that. So what we're saying though is, once again, a duty of inquiry and a very specific inquiry of its agents to find out if anyone else is aware of something being lost, destroyed, or altered by way of, whatever that is, if it has to do with the investigation of Mr. And I think a duty of inquiry is required under the facts and circumstances and what history has told us now, the recent history of the conduct of some officers involved in the investigation of this case. And so that's really what we're asking for, just an inquiry at this stage to make sure that there is an affirmative statement on the record that after inquiry, there's no knowledge of anything being altered, destroyed.
I appreciate Mr. Tipton's honesty on paragraph G, as I was confused as well. Because when it comes down to it, at this point in time, I don't know if something is lost or destroyed. So if I find out, that would be exculpatory, and under the rules, I would have to tell him. So I would tell him. I guess what Mr. Tipton is asking me to do is to actively go and ask every officer if anything is lost or destroyed. When I do my inquiry, I will ask if anything is lost.
Sounds reasonable. Okay.
I think that's it for
That was faster than I thought. All right. Do we want to address paper 31 and whatever the Commonwealth has been docketed as the next entry, which is I'll call it the 2A request. Now that the defense has seen what the intends to do, that seems to me the way that we get the information, if they're going to get it.
Respectfully, Your Honor, they have the information. The information is in the custody of the Norfolk County District Attorney's Office, so not only is 2E unnecessary, it would still be premature when you look at the cases such as Donahue and Lehman.
What if I'm not persuaded by your argument that I ought to be persuaded by this case, which I frankly am not persuaded by?
So the first question is whether or not the documents are under the purview of Rule 14. We believe they are. We're kind of at a disadvantage because, one, we don't have a copy of the protective order or the non-disclosure agreement. So we're at a loss there because I can't specifically articulate what exactly the protective order is, what exactly it covers. And two, we can't even articulate what is in these materials. The importance of Rahim is that if it is physically in their custody, then they have received it. It is in their control. They possess it. Just because a federal agency says, no, it's really ours. It's not theirs to give.
That was very much so in the context of a joint investigation, right?
It was, Your Honor, but in this case, the federal government and the Norfolk County District Attorney's Office were essentially working together. They were working to investigate a homicide that Norfolk was prosecuting. They were investigating the state police for integrity violations, policy violations, inappropriate conduct, failure to supervise. And so this information has been starting to get turned over to us, and as Mr. Tipton articulated, whether it comes to voting or credibility or bias, that's part of what we want to show and what we expect to show. So we believe the material is Rule 14. They have it, ergo we should get it. So I don't think 2 is even necessary yet. If they've indicated they're going to take that road, then that's fine, but that does not negate our argument that it is Rule 14. And the SJC as recent as 2020 has clearly stated that it is in their possession. With respect to the cases they cited in their response, they're relying on Cannone versus Bonnet, which was a 2015 case. I don't believe that's on point. Bonnet is a case in which the state district attorney's office was not aware of the identity of a confidential informant. And so it wasn't in their custody. And secondly, they were saying that it was privileged. We have nothing to show that anything in those 3,074 pages are privileged or protected. We don't know. We've pulled it together from pleadings from other cases, responses from the government, just to know that they have it, roughly what it's about, and then several letters between the district attorney's office and the federal government talking about this material, specifically the officers involved. And the reason I can point to, there's a myriad of reasons why it would be relevant, but what we're able to determine is that Trooper Proctor, who was the lead investigator on this case, the moment he stepped foot into investigating Brian Walsh and the disappearance of his wife, he knew he was under federal investigation. And so his bias, his motive, anything or his integrity is forefront for him. So with all those thoughts, when you're considering all of that, I don't know how it's not Rule 14. I don't know how we're not already in possession of this. And so otherwise I rest on the papers. And they talk about your argument. In Beal, I agree the prosecutor doesn't have a duty to go investigate our case, but they have it. So we're not asking them to go get something they don't have. And in footnote 4 in Beal, which is cited in their brief, it specifically says the government isn't able to simply put their head in the sand if there is something exculpatory. And documents that show that the lead investigator in a homicide case knew he was under federal investigation the moment he stepped foot in the case is certainly...
Isn't it even stronger? Well, I'm not making your argument, but wasn't he already under prosecution?
No, Your Honor. Do you mean
So
Mr.
what's the...
Walsh?
Yeah.
No.
What's the timing of his federal indictment?
Do you mean Trooper Proctor or Mr. Walsh?
I thought you were talking about Mr. Walsh.
No,
that
Mr.
there's bias
Walsh's
because
state
he knew
investigation.
that Mr.
No, Trooper Proctor knew he was under federal
investigation.
the moment he
I thought you were
stepped
saying there was a bias against your client
No.
because he was under
No.
federal law.
foot. No, it's Trooper Proctor.
That's an additional bias, by the way.
Right, but we're just focused on that part. But the moment he stepped into this investigation, and bear in mind, the Norfolk County District Attorney's Office, they control homicide investigations. They work with the state police with CPAC. So now the Norfolk County District Attorney's Office knew that Proctor was under federal investigation, specifically for how he investigates supervision, etc. He now is the case officer in this matter while his case is pending. So that's one of the big reasons why not only are these documents relevant, but they could very well be exculpatory. And under Rule 14, it's not exculpatory, it's material and relevant. And so with respect to that, I would rest on the papers, Your Honor.
Yeah. So, Your Honor, it's my understanding that the federal government has never said that they were investigating officers. That's never been a public statement by the U.S. Attorney's Office in this matter. They have released information to the prosecutors that was subject to a federal protective order signed by a judge that is impounded that I can't see. I have also not seen the materials that were turned over to the Karen Reed prosecution, so I don't know what's in those materials either. I can tell you that I watched a large portion of the Karen Reed trial, and from what I could see, 2 witnesses identified that they had testified in a federal grand jury in that case, when they were testifying in the state Karen Reed trial. It's further my understanding that the federal government acknowledged they were investigating the death of John O'Keefe, not the district attorney's office and not the state police. It's also my understanding that the U.S. Attorney's Office has not said that this investigation is done.
They never do.
They never do. I can say, Your Honor, I have no knowledge of anyone receiving a target warning As far as being a state trooper, the district attorney's office, Canton Police Department, any civilian witnesses, I have received no knowledge of anyone receiving a target warning. And I would suggest that this is premature, that I have filed a TUI request with the U.S. Attorney's Office for the Walshe materials. I told counsel today I think I should file a TUI request for the Karen Reed materials. And I was willing to work with counsel to make it a joint request. I can understand if they want to do their own, but that would be my suggestion, because I would suggest under ALEA, we haven't gotten to the point of the need for the court to become involved and order discovery to be turned over, particularly discovery that if it was turned over, the people who have seen it would be violation of a federal non-disclosure. So I'm not prepared to have someone from my office be charged with contempt. I would prefer that we go down the road of trying to work with the U.S. Attorney's Office and see what those results are, report back to the court, and let the court.
All right, I'll take a look at the cases that both sides have cited, and I'll include whatever my decision is regarding that in the omnibus order as well.
And one last point, I don't think we can say that the U.S. Attorney's Office and the state police work together on this investigation in the matter of John O'Keefe. It looks like it has been completely two different agencies doing two different investigations. I don't see any, there has been no sharing of information until there was discovery turned over in the Karen Reed trial.
Well, Your Honor, it's not, the case law isn't just about specifically whether or not they worked on this case together, but if there is cooperation in general between the two agencies, which clearly there is. And the problem is, there's too much we don't know we think. I don't think it's, respectfully to Mr. Connor, I understand he's willing to make the TUI request, but I don't know how we say we're going to make a TUI request, which when you send a letter to the office saying, we believe you have relevant material information, and then at the same time object to the Rule 14 of materials in their custody. That's no foreign deal on point. You can't put your head in the sand. I don't think it's right to be like, well, someone else in my office knows, but I'm just not going to talk to them about it. I understand if there's protective orders and if the government wants to rely on that at this point, but I think that not only is there evidence that these two agencies routinely do work together, I think the fact that the officers involved in both cases were under investigation for whether it's integrity, investigation, failure to supervise, I think that does count as working together for this case as well.
I would just disagree with that.
All right.
If I may, Judge, just briefly, I don't want to step on anybody's toes here, but when Mr. Connors just said that we didn't want to work with him, I will say we will work with him. I just don't want, and Attorney Porges don't want, that our efforts to work with the Commonwealth dilutes our Rule 14. That's all.
We get the lower hanging fruit, the Rule 17, when do you want to schedule that?
I reached out to Chief Legal Counsel for the state police. They asked for 4 weeks.
Okay.
So with
What does that bring us to? I want to get a date on the calendar and recognizing you're likely going to be up, and we'll work for that one.
Yes, Your Honor.
And so I just want you to know that in advance. I'm happy to do what I typically do, and frankly, what I'll be doing when we try this case or whatever that is. I try cases from 9 to 4. And what I do to accommodate the other business, depending on the length of the case, is try to go on the bench at 1:45 and clear away more straightforward matters. And frankly, put off the more substantial matters to a time when you're not on trial. And the goal there is to keep the case moving and to be as most respectful, frankly, as I can to the jurors who are making a big commitment of their personal time. So it becomes a little bit of a juggling act, but it's doable. You just do it for the 2 weeks. This feels like a 2 to 3 week trial. You're going to tell me later on down the line what it really is, but just on the limited knowledge I know, 9 to 4, Monday through Friday, feels like 2 weeks, but I don't know enough about the science yet.
We're anticipating 4 weeks, and
On a full day schedule?
on a full day schedule. We were just talking about that before we came.
You're probably right. It doesn't feel that way to me, but that's only because you know a hell of a lot more about the case than I do.
We also know each other. We've done a lot of things with each other as far as trial work, and we know that neither one of us kind of wastes each other's time. So we just believe that we're probably in that realm. We also think that impanelment will take 5 weeks.
And my estimate was after the impanelment, which could be 1.
Sure, sir. I was trying to include impanelment, so I think that if you're thinking about testimony, it's probably about 3 weeks.
So it feels like.
Yeah.
But again, your estimates, I'm going to take your estimates to the bank because I'm just entering the case and I know so much more than I do about what it's going to take.
Yes, sir.
So, but that's important and it's a good segue. Anyway, let's get to the reason I mentioned that scheduling issue is I can see you at 9 o'clock in the morning if you want to do that, and I'll just delay my trial on that day till 9:30 or 10 if that works. If you don't like that, and I get that, because you're going to have to deal with the 120 traffic going up there, which is not good. I could see you at 1:45, and I'll give you 1:45 to 2:15, or I can see you at the end of the day. Pick your time slot.
Whatever works for Mr. Tipton, I'm happy to do it.
145 certainly works for me.
All right, let's do the 1:45.
Which day?
Any day but Wednesday or Thursday or Friday that week would be best, because I'm handling the case a lot.
How about January 9th to Thursday?
That's the one date I get.
How about the 8th?
January.
January the 8th.
1:45
Wednesday?
Yes, and if the defendant wants to be there, obviously we can get him there. If you want to waive his presence for that, that's fine too. We just let the court clerk know and each other.
And just so the record's clear, I do have a manslaughter case scheduled for trial for January 7th, but I'm probably going to learn within the next few days if that's going to go or not, but I don't anticipate it. I just don't.
Okay, if it is, we'll find another. I just want to keep everything moving to the best that we can, and I will be agreeable. You're on trial, given the nature of this dispute. I'll also see you on Zoom. So, given the nature of it, the dispute, I don't know that we all have to be physically in the same room. I prefer that, but certainly isn't necessary to get your points across.
Thank you.
All right, but right now we'll presumptively say 1/8/25 at 1:45 in Middlesex, and I'm going to be in Middlesex 5:30, I believe. Definitely on the 5th floor.
Oh, okay.
All right. So let me move to the schedule. Let me see if I can find proposed scheduling order. Every judge pet peeves. We all do. You do too. Your own pet peeves. One of my pet peeves is serial motions to suppress. I like to do them all at once. I never understood why you have a motion to suppress this, that, and the other thing. Just do it all together. Evidentiary, non-evidentiary, put it all together. So I want one date for the motions to suppress. Hard to break it out if you want to break it out. It's all going to be argued and heard on the same day. And so that's going to compress the schedule. The other question that I had about, and these are just general observations when I looked at your joint motion, is there's a relatively brief period of time, as you have it scheduled right now, between the motion to dismiss and the motion to suppress. So in my judge mind, I read one of the two things. I don't think one is really coming and change the schedule. Or there is one coming, and we're setting ourselves up for, we're not going to even get to the April date. Those are the thoughts that are running through my head. This case ought to try in 2025. I think we should pick a trial date in around a year from now. Now that you're telling me it's 4 weeks, I'm much more likely to look to November now. I've said it a couple of times. I'm going to repeat it again, and I'll certainly hear you. You know the case better. When I see things in motions that say there's 27,000 pages of documents in this case, what does that really mean? I don't know, because I don't know what's in those 27,000 pages. Not all 27,000 pages are the same. You know what I'm talking about. And I don't know how much more is coming. But we can compare it to other cases tried here and certainly elsewhere in the Commonwealth and say 2.5 years, it's time to go. And that's what I'm suggesting. So I'll hear from both of you. Who wants to go first?
Well, Your Honor, I can say that as far as the discovery goes, it went in a couple different directions between the grand jury, which was about 1,000 pages. But I think it was a complicated case as far as pulling it together because there was a significant white collar portion. So with that, I understood how the discovery got up to there in numbers. But that being said, Mr. Tipton and I have had a long-standing relationship and working on cases together against each other. And, I think that we have a really strong relationship on trying to get to the heart of the issues. We talked about trying this case in 2025, and we were looking at potentially late October. And I'm looking at the calendar right now in front of me, and I think October 20th, 21st is the second to last week in October. To me, that gives us about a month before Thanksgiving, which is a nice target. I think it also makes it easier to get panel jurors. I think once you start crossing towards holidays, it becomes a little more problematic. So that would be my suggestion as far as trial.
And just so you know, that's 6 weeks before Thanksgiving. That date you used to.
October 20th is 6 weeks.
Yeah.
Late
Thanksgiving is again November 27th.
So that's, given impalement being a long time, could be like over 5 days, could be 7 now. That gives us enough time.
After talking with the district attorney and our client.
If that date is good for you, it's good for me.
That's right.
It's not mine.
Someone's media box has a phone or a device that's vibrating, so if we could shut that off, that'd be great.
I think it's stopped now. So, all right.
Do we want to work that?
Yes, we're going to work backwards right now. So what was the date that you just said?
So October 21st, Tuesday, October 21st.
Okay.
If I could,
I just want to add, does anybody want me to ask Civil and do our start on the 20th?
Might be a good idea.
Yes, please. It's been a few years since I sat here, so it's,
Yeah.
what is it, Mondays,
And
Tuesdays,
Tuesdays.
and Thursdays.
Exceptions.
Wasn't that long, I guess it was about a year and a half ago, just, all right.
Judge, if I could just start nailing down
Dates, yes.
And just so you know, the Commonwealth, we all met and we hashed over a bunch of dates too. The court will find those dates real. But having said that, brief, I'm just going to say this. I didn't have the case for date.
I know, you came on board about a year ago,
I
right?
was in the middle of a double homicide case came up and I really didn't look at anything for a few months. And when I say 27,000 bits, that's an underestimate. And included in some of that is video surveillance, hours of video surveillance. There's also transcripts of statements that still need to be properly transcribed in some instances. But aside from that, the forensic testing in this case
Thank you for mentioning that.
is extremely complicated and it's still ongoing. And the Commonwealth and I, Porges, we're trying to work out an issue with the DNA testing and the exhaustive testing that is a very critical aspect of this case. And we expect to be able to, file a motion to address the issues we have. But the short story, judges, I hope the court understands. When we selected the dates for the proposed scheduling order, that was after we met a number of times. We talked about what the case was, our understanding of the case. And I want the court to know that we didn't suggest dates as a subterfuge to suggest, we'll just.
And I don't think that anything I said in substance, or certainly in my intent, sometimes it gets lost in my translation, in my delivery, was meant to suggest that wasn't in the realm of possibility. I just think that it's probably not the best thing for the case. And I'm going to be here to try the case, whether it's in October or it's in April. But it's going to be tried in an efficient manner. And there's a reasonable view to, it's my pet peeve. I don't like serial motions to suppress. It's just as simple as that. But some people like serial motions to suppress. You don't know who you're getting on the other side of the bench. Some people like to take it in smaller tranches. I'm just telling you that I think there's a way to be more efficient. Of course, I'm not going to force or pressure anyone in this case within reason, and I'm never going to have to do it with counsel that I have here to make you do something that you're not comfortable going forward. I think we can be more efficient with the schedule, and I'm going to do my part to turn around the motions you do present to me quickly.
And on the motion, just now, limiting the issue of motions to suppressing the dates. After the Commonwealth and I, and Attorney Porges all talked, we think there is a need for 2 separate dates. And if we could, I would ask to come to sidebar to tell the court, to give you a reason that I'd like to do it at sidebar.
All right. Proposed voir dire. I don't know if you're going to want to do a questionnaire. If you do want to do a questionnaire, you can reach out to the court. I have a couple of ones that I've used recently and homicide cases, and I can give those to you. It does, in some ways, make the impalement. I don't know if it goes faster, but it raises issues in a more sensitive way.
I appreciate that, Judge. We've been working on a questionnaire already.
Okay, great.
I would appreciate anything.
I'm happy to share them. They're available, and I think that every time you look at a different questionnaire, different issues come to light that you think might apply to your case, so I'm constantly tinkering with it. But I'll share you that I've had in the last couple of years.
Yeah, you did that by September 26th.
Thank you.
And objections or oppositions filed by the 3rd.
That works for everybody?
Yes, sir. Yes.
Let's do, I think we agreed to 1-2 on the motions to suppress.
First motion to suppress, forgive me, will be evidentiary.
Yes.
We were suggesting April 7th, and then the following would be for the remainder of the motions to suppress, May 12th.
Dates on the motion to dismiss.
July 14th, let's see.
Just stay tuned for where that's going to be. Any other dates we need to put on?
We have a potential motion about the DNA testing.
What is going on with DNA testing? How long has the lab had it? What needs to be done? What happened?
So the lab has tested samples from objects taken out of garbage that was located outside the defendant's mother's apartment. It's also tested samples from inside the family home in Cohasset. What is at Bodie right now is tissue that was found on a saw in the garbage at the mother's apartment. That can't be done by our state lab. Essentially, these items go in a wax paraffin block, and Bodie has the ability to take slices from the block and do DNA testing from that. There are 6 samples that have the potential of having results. And so where we're at is that they have the potential of being destructive. And so that's where we're at as far as potential motion. Bodie has a different, and Mr. Tipton can probably speak to this better than I can, has a different policy and procedure for outside experts coming in and viewing their testing. And also, there's a cost. And Mr. Tipton and I have been talking about the cost. And it has to get paid one way or the other. The question is who's going to pay it? Or is the government going to pay for all of it? And so we're trying to figure that out, and that might be the subject of a motion.
Okay, anything you want to add to that?
So the money issue will be resolved. I mean, we want $20,000 just to have someone stand there and watch. However, the real issue for us is the observation and what voting requires and limits any observer is seen as compared to the Mass Students and some other ones. So we anticipate filing a motion, like we discussed it with the Commonwealth, arguing that voting needs to change their protocols for this case, especially given the gravity of this evidence that's being examined. And we'll file a motion, and that's the cause, which probably is not much to talk about. It's the other.
Okay, but when can we take that up?
I think we can probably do it the same, on that same January date.
Yeah.
On the 8th, because I don't think it's going to, I think I'll file something I can rest on the pleading.
All right, let's do it.
Yes, Ron.
Two of you work together with regard to when it's going to be filed and give each other enough time on it. Propose.
Yes, Ron.
All right, any other dates we need to set?
The only other thing is a discovery date, but I guess maybe we should wait and see. I know there's there's other production of discoveries coming, and I think when we come back, on January 7th, is the final.
All right, that makes sense too, and I think he'll have the benefit of my ruling at that point. We'll know what additional I think he ought to be producing.
Yes, Ron.
The addition of that motion, does that change the Zoom option for January 8th?
It doesn't in my mind if you feel differently.
I was thinking on being there, but I know.
You're welcome. All of you are always welcome wherever we are. But if it becomes an issue that we would have to cancel the hearing versus doing it on Zoom, then it would be my strong preference to do it on Zoom. So you have that option. Just let the clerk know what you're doing. And obviously, it does create, obviously, some problems. The defense counsel's Zoom and defendant have had a number of issues with facility not putting them on, and then it gets delayed. And so sometimes if there's two counsel, one will come up and the other will be on Zoom. Just work to make sure that everybody's coordinated so we don't lose the date.
Yes.
Or have the defendant transported to Middlesex. That is there. I'm sure that, given that there's some moving parts, I'm going to just alert you to the prospect.
Now that you've said you're sure it won't happen.
All right. So I'll see you all on the 8th. Before we close, is there anything anyone else wants to raise that I did not raise?
Yes. It's a housekeeping matter, but protectable.
Oh, yes, Your Honor. We submitted two protections. They're agreed upon without prejudice, but it relates to discovery and the bias that we've identified.
Okay. So let's take a look at them. I'm having to push those orders.
Thank you, Your Honor. Counsel will receive them.
All right. Excellent. Thank you all.
All right. Thank you.
Good